All right, let's start our discussion today with police questioning. First of all, we should know that the Fifth Amendment to the Constitution gives us our right to remain silent, which means that a defendant in a crime never has to answer any questions. If you are, let's say, arrested by the police or questioned by the police, it is your constitutional right not to answer any questions. You probably have to give them your name, but if they ask, let's say you're pulled over for speeding, and the police ask who you are, and you give them your ID and your name, and they ask, where are you coming from? That's up to you if you want to answer that question or not. Certainly there's no reason not to answer that question, unless, of course, you've just come from robbing a bank, and then you don't want to give that information, obviously. Either way, it's the Fifth Amendment right that we have not to answer questions. That comes into play sometimes because police oftentimes will question their suspects, the people that maybe they eventually arrest. And as long as police do not coerce a confession out of an individual, then that confession is usable. See, you have the right to remain silent, but that doesn't mean that you have to stay silent. So if the police ask you questions and you answer those questions, that's a fine. There's nothing wrong with that. It's not a violation of your constitutional rights. And even if they ask, what did you do today? And you said, I just robbed the bank. That statement, I robbed the bank, is evidence that can be used against you, as long as that statement you made was not coerced. Now, coercion is any way that a confession is gained that is less than voluntary. So if they beat a confession out of you, that would be a coerced confession. They threaten a confession out of you. Like they say, hey, if you don't tell me where you've been, or you don't tell me about this crime, we're going to beat you up. Well, that's a threat. Intimidation. Things like that. Those are coercion. And remember when we said the Fourth Amendment, we said evidence obtained illegally cannot be used against you in court. That's the exclusionary rule. That applies to testimonial evidence too, things that you say. So as long as what you say was freely given, then it is evidence that can be used against you. But if what people say have been forced out of an individual, then that is considered police coercion. The biggest question we have on this is the Miranda Rights. Now, the Miranda Rights originated from a court case known as Miranda versus Arizona. It went before the Supreme Court in 1966. Some of the details of the case are a man named Ernesto Miranda was arrested for kidnapping and raping a woman. And Miranda, there was a few witnesses, or at least the victim could identify Miranda in the car he was driving. I would think he was driving some kind of white vehicle. Another witness could put Miranda in that vehicle. Either way, Ernesto Miranda was a suspect in this crime, and he was arrested and then questioned. And for a couple hours he was questioned, but he really wasn't coerced in any way. He was not threatened, he wasn't beaten. Just questioned for a couple hours, and Miranda confessed to the rape and kidnapping of this woman. Well, Miranda was tried for the crime, and all the evidence they had against him was used, including the confession, and he was convicted of the crime. Miranda then and his lawyers appealed, saying that his right against self-incrimination was violated because Miranda didn't know he had a Fifth Amendment right not to speak. Now, the Fifth Amendment of the Constitution doesn't say that we have the right to remain silent, and police must tell us that. Okay? The Fifth Amendment says we have a right against self-incrimination, but it doesn't say we must be informed. But his argument was that because he didn't know his rights, it was essentially coercion. And the Supreme Court agreed. The Supreme Court ruled that custodial interrogations are inherently coercive, which means that if you were in custody and you were being questioned, then that is by its very nature coercive, unless the police have informed you of your rights. And they actually spelled out the Miranda rights. Now, you probably heard these on a TV show somewhere along the way. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you're being questioned. Now, the rest of this, you can hire a lawyer. This deals with a different case. In the Miranda ruling, they kind of put two cases together. Your right to an attorney, which we'll talk about on another day, and then your right to remain silent. And the Supreme Court wrote these warnings, which are now referred to as the Miranda warnings. Miranda warnings really are misunderstood by a lot of people. I get this question sometimes where people say, hey, police didn't read me my Miranda rights when I was arrested. I'm free, right? I got them on a technicality. And that's technically no, that's not correct. So let's look at what the Miranda rights, the details of the Miranda rights. I had a lawyer once give me this in a formula. Custody plus questioning equals Miranda, which means that if an individual is in custody and they're being questioned, then the Miranda rights are required. Now, both of these elements must be present. Okay, let's say that somebody is in custody. Let's say that you have been arrested for a crime. You are handcuffed, you're in the back of the police car, which that would be custody, and they're driving you to the police station, but nobody's asking any questions at all. And you blurt out, I just robbed the liquor store. Now, your Miranda rights had not been read to you. You were in custody, but you weren't being questioned. So your Miranda rights were not required. Your statement, I just robbed the liquor store, can be used against you in court. Or let's go a different way. Let's say that a police officer comes to your door and knocks on the door. And you answer and they say, can I ask you some questions? And you say, sure, come on in. So you're sitting at your kitchen table and the police officer is asking you questions. And they ask, what did you do last night? And you said, I stole a car. All right. They had not read you your Miranda rights. Certainly they were asking you questions, but you were not in custody. You were sitting at your own kitchen table. You were free to leave. You could ask the police officer to leave. So again, Miranda rights were not required, and the statement, I stole a car, is usable against you. However, let's say that you are in custody. Let's say you've been arrested, you're handcuffed, you're down at the police station, you're in a cell, you can't leave. And police are asking you questions. You know, what were you doing last night? And you say, I burglarized a house. Now, if they had not read the Miranda rights, and you were in custody and you were being questioned, your statement, I burglarized a house, or whatever incriminating statements you make, will not be used against you in court. Now, that doesn't mean that you're going to be innocent. If Miranda rights were required but they were not read, it just means that what you said is not allowed in court. It doesn't mean that other evidence can't be used against you. Remember the Miranda case? Ernesto Miranda was granted a retrial because they said his statements that he made, his confession that he made, was not usable. So they retried Miranda, and they didn't use his confession this time. But there was still enough evidence to convict Miranda. So if the Miranda rights have not been read to you, it doesn't mean you're innocent, it doesn't mean you're free, it just means your statements can't be used. And sometimes those statements are very, very important in a case. But keep that in mind, a misconception of what Miranda actually means. Now let's go on a little farther down the line. Okay, so you've been arrested, or an individual has been arrested. The next step then is not the trial. And actually, if we think about it, there's kind of a long timeline from the arrest until when the trial begins. Probably about 9 months, even if there actually is a trial. So let's go through a couple of the early things that happened prior to the trial. First of all, the person is taken down to the police station and booked. That's pretty simple. And then they're going to have their initial court appearance, which is going to happen probably within 48 hours of their arrest. Now, what's going to happen is bail will be offered. Now, bail is money that will get you out of jail if you haven't been convicted of a crime. Okay, and at this point, you're innocent until proven guilty. So let's say that you were arrested on suspicion of a house burglary, but you haven't been convicted of that, but they're holding you in jail. Well, you may be offered bail, sometimes it's referred to as bond, which is money that will let you leave, kind of. Okay, so let's say you pay a $5,000 bond or $5,000 bail. What that is think of it as a security deposit. That $5,000 is yours, but they want to make sure that you show back up for all the court hearings and the trials that it's going to come. So the purpose of bail is to ensure that you show up to those things. And as long as you show up to all those court hearings and the trial, then you will get that bail money back, even if you are guilty of the crime. So the purpose of bail is to get you to return to court. It's not denied very often. Sometimes it's set very high. Remember, bail does not have to be affordable, but it rarely is denied. Now, it might be denied if you're a threat to flee, probably the biggest reason. Let's say that you are not from this area. Let's say that you're passing through South Dakota from Chicago. They may believe that you won't show up for trial if they're given bail. Or let's say that you have skipped out on bail a number of times in your history. Then the courts may say, you know what, you skipped bail a bunch, we're not going to give you bail here. Typically, they'll still give you bail. It just may be set at a very high amount. If you've threatened witnesses or other people, bail may be denied. Sometimes bail is denied. Sometimes it's just set very, very high. So bail may be set at $1 million. Now let's say you don't have $1 million. You can't afford it. Well, then you don't get bail. You know, that's the way it goes. Now you may be able to get a bail bondsman, and a bail bondsman will essentially put up part of the money for bail. Okay, so, and I don't know the exact details of other work, but think of it as like a loan. And let's just use, for an example here, let's say bail is $10,000. Let's say the bail bondsman says, you put up $1,000, we'll put up the next $9,000. But they're going to charge you $1,000 to do that. Okay, so they put up that money, the vast majority of it. You get out. If you don't show up, they're out. The bail bondsman is out the $9,000. You're only out the one. When you do show up, they're saying the fee is $1,000. Okay, a bail bondsman is essentially a loan to get bail. One of your early hearings is going to be a preliminary hearing, and a preliminary hearing is where a judge is going to decide, is there enough trial to continue on with this case? Is there enough evidence, to continue on with this case? Okay, so it doesn't determine guilt or innocence. It's just very early on, you've been arrested. Let's say 5 people have been arrested for that burglary. Turns out there's not much evidence that you were present at that time. And maybe they say, you know what, there's no reason to hold you because there's not enough evidence to prove that you're guilty later on. But if they believe there's enough evidence to at least try the case, then they'll move from that point. We also have what is known as an arraignment. Now, arraignment is where the defendant is officially indicted. And what we mean by indicted is to be officially charged with a crime. That's what the word indictment means. So, right now you're just arrested on suspicion of burglary, but it hasn't been any official charge, not before the court. Well, at the arraignment, you'll be officially indicted. So now you're charged with, let's say, first-degree burglary. At that point, the defendant will, which is you now, or whoever has been indicted, will issue a plea. And they really have 3 pleas that they can enter. Guilty, in which they tell the court, I did it. I committed this crime. If you plead guilty, there will not be a trial. There's no reason for the courts to have to prove guilt. You just told the court right now that you were guilty of the crime. You could also plead not guilty. And if you plead not guilty, you said, hey, I'm not guilty of these charges against me. And what happens then is we just keep moving on down the line of the court proceedings until we get to the trial, and then a jury will determine if you're guilty or not. And then sometimes someone will plead no contest, or actually it's called nolo contendere. No contest means that you say, I'm going to accept guilt without actually saying I'm guilty. So you're not going to contest the charges against you. You're going to accept the punishment that will come. Sometimes people will do that because a guilty plea can be used against them in civil court. a no contest plea is not really an admission of guilt, but it's an acceptance of punishment. You basically are saying you're just not going to fight it. So if you plead not guilty, there's going to be a trial eventually, unless you change your plea somewhere along the way. Now, to make things a little more difficult, in a state court, you can have a preliminary hearing. In federal court, you can't. The federal Constitution guarantees us a right to a grand jury indictment. A grand jury is a group of people, usually 23 in a federal grand jury, and they determine if there is enough evidence to actually indict someone. The same thing as what I said a judge did here. Well, it plays essentially the same role. 23 people, they listen to the evidence that the prosecution has. They do not determine guilt or innocence. That's not what they do. There's two types of jury. The grand jury meets early on. Later on, when there's a trial, we have what is known as a petit jury, and they'll determine guilt or innocence. But the grand jury does not determine guilt or innocence. What they do is determine if there is enough evidence to actually charge an individual with a crime. It's used instead of a preliminary hearing. It's used in all federal cases. And in some states, many states actually, they use a grand jury. If you go to Sioux Falls here and are arrested for a felony, there will be a state or a county grand jury will determine. Now, they don't use 23 people, but we don't use a preliminary hearing in that manner. We use a grand jury. Okay. That there is sometimes some confusion on what a grand jury is. Remember, a grand jury does not determine guilt or innocence. That's a different type of jury at a different time. A grand jury just determines if there's enough evidence to continue with the case. All right, that is as far as we're going to go today.